Hello friends, Namaskaram, how are you? Myself is Dr. Jinesh Soni. I am an advocate. Har Har Mahadev, Jai Shiv Shambhu. In today's class, we will discuss about disproportionate of the asset. As the name implies, if the asset of the public servant is going to be disproportionate to the known source of his income, in that scenario, he could be prosecuted as per the protocol of Section 13, Subclause 1, Subclause B of PCA, or as per Section 13, Subclause 1, Subclause E of PCA. And if it is found that the money has been diverted, and inter alia, the family of him assisted him to do the crime, in that scenario, they could be prosecuted as per the protocol of criminal conspiracy or as per the protocol of abetment, which is punishable as per section 109 of IPC. So basically, if we are indulged in the said case, what we can do, what will be the practical approach to discuss all the scenarios, I will specify you the points or the steps in the easier manner so that you could get the proper information on the subject. I request all of you to maintain a proper notebook along with pen so that you could maintain your information accordingly. Usually, when we are prosecuted, as per section 13, subclause 1, subclause E of PCA, we inter alia try to fight the case or try to contest the case in such a manner as if it is a murder case. I want to clarify that the case pertains to disproportionate of the asset. Inter alia depends on the accounting. If the accounting done by the concerned anti-corruption bureau or by the vigilance is not proper, it is not as per the norms, and it is against the law, in that scenario we could have the benefit. Because if the entries are not going to be placed on the proper site, and apart from that there is a mismatch in the accounting, or if the accounts are placed against the law, then we could have the benefit. For example, if the income of your wife is not added to income of yourself, in that scenario it is a case of mismatch on the part of concerned anti-corruption bureau. So if the authorities are not going to investigate the case in the proper way, then the accused could chalk out a case for the unfair investigation, and on that ground the accused could claim the unfair investigation and subsequently the acquittal or discharge as well. I want to specify you the recent judgment of Honorable Supreme Court on that subject, which is dated 4th of December 2024. In that case, the accused was prosecuted as per section 13, subclause 1, subclause B of PCA. The prime allegation of the bureau was that he is having the asset which is disproportionate to the known source of income. And finally, there was a FIR, and ultimately the accused public servant was prosecuted as per the protocol. The prosecution had been challenged by the accused on ground that the agencies inter alia ignored the legal provisions, and apart from that the accountings are not done as per the protocol, and that's why he claimed the discharge. While submitting his argument, he specified that the anti-corruption bureau or vigilance only considered his income in isolation, not the income of his wife. As per legal provision, if the wife is earning, and apart from that the source of money is specified, in that case the husband specified that his wife is taking yoga classes, and apart from that the earning is shown in the income tax return, in that scenario the income tax return are required to be considered. And apart from that, if the concerned public servant is having the income or corpus in form of capital gain, in form of FD or LIC maturity, and apart from that if the income is from the legitimate sources, it is required to be considered and it is required to be added back in the income. So as per submission of the concerned accused, Honorable Supreme Court intervened and finally added the income of wife in the income of husband. And when it was done, it is found that the income is on the higher side as compared to asset and expenditure value. And finally, the accused had been discharged. Honorable Supreme Court observed that in case of Section 13, subclause 1, subclause E of PC Act, the scrutiny process cannot be in the mechanical way. Due compliances are required to be done. If the accounting are done without any specification, and apart from that, there is no legal compliances, everything appears to be in the mechanical way. In that scenario, the charges of Section 13, subclause 1, subclause E of PC Act are liable to be quashed. So basically, we could say that it is a big relief to the concerned accused. So whenever you are going to fight the case, just have the proper cash flow statement or fund flow statement on record, so that we could specify the source of income, we could specify the source of expenditure, we could specify the source of asset, so that we could establish a proper balance between the income and asset and expenditure. So if we are able to proportionate the income versus concerned asset, in that scenario, we could be on the dominant side while submitting our submission on board. But if our way is totally unspecific, it is orthodox, in that scenario, we could not be succeeded. So we have to submit a proper chart showing the proper proportions of the asset and the income to secure our acquittal in such cases. So I think that I have specified you how to proceed and what will be our modus. See you in the next video. Till then, Jai Hind, Jai Bharat.